Edwin, you can hear me okay?
Yes, Marjan, we can hear
Okay,
you.
perfect. Thank you.
Yes, we're live.
Perfect.
Uh, Firstly, sorry for the delayed start. We had some technical issues. Thanks everyone for joining in. We have Marjan here with us as well. We had some technical issues. That's the reason why the delay. So, without further ado, I would like to begin the webinar. Today's topic is basically EB-5. It's called EB-5 Playbook. We're going to start talking about a couple of topics with main emphasis being on SDIRA and a lot of chatter that's happening around that. Apart from that, obviously, the obvious question with regards to the September 30th deadline that's coming up, what the news around the AOS, and as we speak, the Visa Bulletin is out as well, so we'll be talking about that too. Directly jumping into the topic, but before that, let me just talk a little about the company that I'm representing here, U.S. Immigration Fund. So we are one of the top EB-5 regional centers in the space, and we've been in the business of EB-5 for almost 15 years now. Raised close to $3 billion in EB-5 capital, done across the length and breadth of the country. We've done close to 25 grade A real estate projects, worked with close to 6,000 plus families, and have had a wonderful experience to share with them. Also, we have Lawmaks here joining us in the webinar. Just give me a second here. So a little about Lawmaks. It has been founded. It is one of the top immigration law firms with core practices in the EB-5, E2, and L1 visa categories. Founded by very own Marjan, who's here today. They have physical presence in Stamford, Connecticut, New York, and Dubai, and serve to clients across the globe, and they are multilingual as well. In Connecticut itself, they have been rated as amongst the top 10 immigration law firms in that particular region. A little about myself. So I've been with the company for almost 2.5 years now. This is my second innings with U.S. Immigration Fund. Prior to this was in the private equity space, working with JP Morgan and 361 Wealth and Asset Management. In the USIF EB-5 space, this is my second stint. Have worked pre-RIA and now post-RIA, so have had the opportunity to understand the dynamics of both the governance structures which were there in place prior to this. Marjan has been with Lawmaks. She's the founder of the company. Primarily practices EB-5 and has been rated as the top 20 within the top 25 EB-5 attorneys in 2024-25. I think she's having some issues with her camera. Just give me a second while I try to connect with her on that. While we have Marjan joining in again, I will just run you guys through what is the content and the objective of what we are trying to establish here. So currently we are looking at, so EB 2025-26 has been a marquee year with regards to the EB-5 space. A lot of changes have come across, a lot of changes which affect you as an investor is in the pipeline, with a sunset date coming across on September 30th. That is a key deadline as well. So we'll be talking in detail about that. SDIRA is one of the hot topics right now. Why is it no longer a viable option from a funding strategy standpoint? The changes in the USCIS adjustment of status, the duration of status which impacts F1 and J1 visa holders. We'll be talking about that. The most recent Visa Bulletin that's come through, and the 30th September deadline that we're going to talk about as well. So we just spoke about the webinar flow. We've already lost a bit of time, so we directly jump into the first topic in discussion here, which is your SDIRA challenges and alternative funding strategies. So, Marjan, to begin this webinar, I would firstly want to ask you to shed some light around what is SDIRA and how is it different from the standard IRA or the 401k that most employees hold.
Of course, of course. First of all, thank you so much for having me here. As you all know, my name is Marjan Kasra. I'm the founder of Lawmaks. Happy to be here. Sorry, guys, about the technical difficulties we're experiencing. So hopefully this will go more smoothly from here on. So as far as SDIRA is concerned, it stands for Self-Directed IRA, as I'm sure a lot of you know. And essentially, this is a vehicle that allows you to avoid having to break your IRA and to pay taxes and penalties. And it's something that is relatively new in the industry. To be quite frank, Edwin, I was somewhat against it when it first came out because of the fact that it was new. And generally speaking, USCIS does not like anything that they don't understand or that is new to them. In fact, there were initially a lot of RFEs issued and questioning primarily Alto IRA as to what is this compliant, etc. So that said, we started to see a lot of approvals in the industry, and that's why a lot of lawyers, myself included, started to utilize self-directed IRA as a form of funding for EB-5. Now, what it does is that it does allow you to avoid taxes and penalties, as I said, and it allows you to roll over a previously held IRA into your present IRA, and from there it travels or rolls over to a custodian like Alto or Equity Trust. These are the two big companies that used to administer this. And then from that point on, the custodian would sign off on having you utilize a part of your previously held IRA or 401k into the EB-5 investment vehicle. And the reason, Edwin, this was okayed is because of the fact that EB-5 investment is in fact considered an investment. And so a lot of people have used it so far. A lot of people have gotten approvals. The issue started roughly 2 months ago with Equity Trust, which is one of the larger equity trust companies that helps acts as a custodian for EB-5. They came out and said that, look, this thing does not look compliant. So this was something that came up from the chain of command, if you will. And from that point on, they stopped administering EB-5 as custodians.
Sorry to cut you there, Marjan. And that brings me to the question as to initially it was approved. You just mentioned that there were cases where SDIRA was approved. But what are the current issues with SDIRA and why are they not being accepted as a form of funding for EB-5? Because we speak to a lot of investors and we hear that they want to do SDIRA, they want to utilize that, but what is the issue right now that you foresee or what you've experienced?
Yeah, it's more of a compliance issue, Edwin, right? So it's not anything where IRS has said this is a no-go. It's nothing where USCIS has said this is not to be used anymore, right? But the concern is that this has had some type of a ripple effect in the industry, right?
Mhm.
So because of Equity Trust's opinion, now Alto IRA stopped administering these about 2 weeks ago. So Alta IRA is out, Equity Trust is out. It's my understanding that there's another custodian called New View who's still administering these. Problem, guys, is that this is more of a compliance matter, more of a private company compliance matter where companies are wondering whether they want to deal with this or not, right? It does not mean the IRS says it's not kosher. It does not mean that USCIS is going to stop approving them. That said, in reviewing these things on a case-by-case basis with my clients, I do try to isolate a different type of fund, a different source of fund, just to keep things more conservative and to keep a headache out of your daily routine. Are they going to start denying these cases at USCIS? It really remains to be seen. I personally don't think that they will. I think what it may come down to is the IRS maybe imposing some type of a tax and penalty for people who have already utilized it. That's the worst case scenario that I can see. Is USCIS going to use that as an excuse to deny cases? I very much doubt it.
Okay, and you just mentioned that you are having conversations with prospective EB-5 investors, and there are alternative options that you're suggesting. So what are these alternative funding strategies that you are actually speaking to your investors about?
Absolutely. So it's important to, like, not all cases are the same, as you know, Edwin. We sometimes uncover during my conversations with the investors, we do uncover sources that they had not thought about. To be quite frank, money from India does scare a lot of people, but it's something that should be looked upon. I have personally done a lot of funding from overseas. As long as it's documented properly, you should not be afraid of it. So that's one thing that I do prefer over SDIRA these days.
Got it. Got it. So without pondering too much on this, because you have actually answered most of the questions which at least we come across from an investor standpoint, and I think that should address the SDIRA part. I would also like to kind of move into the next topic, which is the adjustment of status and the duration of status, right? Because there has been quite a few changes which have come across from that standpoint. So in May, USCIS issued a reframing adjustment of status as discretionary or an extraordinary relief, right? Immediately, probably, I think in a couple of days' time, they walked back on it with a public statement. So how should investors kind of, read the gap between the operative guidance and the headline?
Sure, sure. So yeah, it did create a lot of panic in the industry back in May. And as you mentioned, they did kind of try to explain it a little bit further. This is what the administration does, especially the Trump administration. Unfortunately, this is their MO. They do create fear. They do come out with these outlandish policies, and then they kind of like explain it later. So what we're doing, just to be proactive, and just for those of us who don't know about the policy memo, is that the adjustment of status has always been in the law. It's within the INA, and it is 245 INA is still in existence. So let's just be clear that the law has not changed. The law still allows adjustment of status on a case-by-case basis. We've never had an issue with adjusting status for someone who's been here on a long-term basis. I think with the individuals that they are potentially targeting are individuals who come here on a tourist visa, and then they decide to stay, right? So to be quite frank and to be quite fair to the administration itself, I think they do have a point, and they don't want the system to be abused. They don't want people to come in on a tourist visa and then with the intention to stay, and then just come in and stay. They're going to go to Las Vegas or have fun or something and then end up staying here. So that part I do understand. But for individuals who are here on long-term non-immigrant visas such as H-1Bs or even F-1s, I don't
Marjan, we lost you.
hear me okay? I'm sorry.
Yeah.
Can you hear me okay? Sorry about that. Okay.
Yeah.
But so for individuals who are here on a long-term visa, I do not think you should have any difficulties. But just to be proactive, what we've done at my office is when we're filing the adjustment of status, we are filing an affirmative statement, kind of putting it out there that, look, these guys are good individuals. They're hardworking. They've been here for a long time. And we're trying to be proactive. And we have started to insert a statement from our law firm and an affidavit from the clients to help that process, just in case they start to implement them. We have not seen any implementation yet. I think the worst case scenario is that they may start actually issuing interviews for individuals. That's a possibility. But quite frankly, Edwin, I have not seen an issue with it yet, and I don't expect to see issues with H-1Bs and F-1. And you know what? That's what lawyers are here for. So we're here to fight for you, and we'll deal with whatever comes up.
Absolutely. And that's where the experience comes in as well. In fact, you've already answered a part of my next question. So the remainder is that are dual intent categories positioned differently as of now? How do you see that?
So the dual intent H-1B and L-1 are the only two visa categories that are of dual intent. So I think H-1Bs and L-1 visa holders are going to be the least likely to be impacted by this. F-1s are not dual intent, but for individuals who've been here for a long time, I still think that they do have a leg to stand on, and I think they should be okay if they file.
Got it. There has been a recent announcement with regards to changes in the duration of status, especially impacting the F1 and J1 holders, right? So, Marjan, if you just add a little about what is coming and what does it mean for students and recent graduates on OPT and who are weighing EB-5 as an option.
Absolutely. So yeah, as you said, we've always had a D/S or duration of status for individuals who come in on an F1 or a J1 visa. Unfortunately, they're starting to put expiration dates on those, right? And
Mhm.
so it's just the administration's policy to limit immigration overall. Right. Now, does that mean that a student cannot file for an EB-5? Absolutely not. You can still file for EB-5. You can still file for adjustment of status. In fact, for individuals who are going into an EB-5 program, the law does allow for you an additional 180 days post expiration of your status. So this is only because you're entering into an EB-5 category. And so for those of you who are here possibly beyond the 60-day grace period, hope is not lost. So I do want you to talk to an immigration attorney and explore whether it's possible to still file for your EB-5 and adjustment of status. And again, the law has not changed. Are they going to be tougher on individuals? Most likely. Are they going to have the ability to prevent people from adjusting? Not necessarily. Again, the law has not changed. It's still the same. Are they going to vet people more? Absolutely. They may start having interviews, etc. But I want individuals who are maybe have lost their jobs or individuals who have run the course of their J or F1 not to be dissuaded. Do consult an attorney because there still may be hope for you.
Great. In fact, Marjan, I also wanted to understand from you, how are you advising investors to choose between an AOS and consular processing right now? And what are the trade-offs between the two? Because a lot of people are still considering that.
Yeah, so it's a tough question, but generally speaking, Edwin, adjustment of status is always the best, right? We always, at my law firm, we say a body that is overseas, it's a body we have no control over. There's this concept of consular reviewability, non-reviewability concept at the embassies. If somebody at the embassy decides against you, it's very difficult for the lawyers to really help you at that stage. So we do always recommend for you to adjust status inside the U.S. provided you qualify. And so again, everything is on a case-by-case basis. If you're deciding whether to consular process or do adjustment of status, it matters a lot what your situation is. For instance, if you have children who are about to age out, I would definitely choose adjustment of status over consular processing. And the reason for that is that you're more likely to be able to freeze your children's age and utilize the Child Status Protection Act inside the U.S. If you're outside, then you're likely qualify for an interview a lot later than you would inside the U.S. And that time lapse could mean your children may age out. So if you have kids who are like 17 years or older, you should start thinking, strategy and definitely discuss that with your trusted lawyer because a decision like that could make all the difference. And
And
some people, Edwin, some of my clients are actually choosing to put the investment under the children's name just to preserve and make sure that they're going to be okay. Because quite frankly, most of the adults in their 50s and 60s, they really do care for they're doing this for their children. They're pretty much settled in their ways, either if they're here or if they're overseas, they could have pending EB-2s. And I do have some clients who do decide to just put this under the child's name, the investment.
yeah, we do come across that quite often as well, Marjan. And because we're talking about the AOS, any suggestions that you would want to bring about in the conversation where uh, an investor could make or take some steps in order to strengthen their AOS petition?
Absolutely. So this comes down to the subjective interview that they may be undergoing, right? So if you have a DUI out there, let's talk. Let's make sure that if there's a way to file a motion to like reopen an adverse judgment or something. I quite often work with criminal lawyers that represent some individuals who've had some issues in the past, and
Mhm.
there may be things you can do to clean up the record or to take steps to remediate anything adverse that may be in your record. But I tell my clients, join a soup kitchen, do some volunteer work. I mean, these are things, these are little things that you may already be doing anyhow, but these are things that we need to be highlighting in our petitions to advocate on your behalf. So we are, as I said, putting in extra petition information for individuals who are doing adjustment of status, just to highlight what good stuff they've done, to kind of like discuss if they have an arrest record or something. We try to address that head on, so that it will hopefully help them in the future.
Got it. Got it. Thanks for the insights on that one, Marjan. With that, I would like to move to the next topic, which is basically the Visa Bulletin updates and the adjudication trends, right?
Yep.
The unreserved category and the set-aside categories are telling very different stories as of now. What is the split, and why does it matter for an Indian investor deciding where to file, under which category?
Absolutely. So the Reform Integrity Act, as we know, it was a game changer. The Reform Integrity Act of 2022 is where the Congress set aside a number of visas that would help, especially India and China, right? Nationals of India and China. Why is that? Because the unreserved categories, we used to have to wait 20 years for some Chinese nationals just to get an interview. Similarly with India, it used to take several years before you qualify to even be interviewed if you're overseas, or to get an approval for your I-526 and then have a visa be made available to you. So the reserved visa categories are a game changer, Edwin. And I do think that Indian nationals have especially if you're inside the US, you have really no other alternative. In order for you to qualify for an adjustment of status, you have to be in an unreserved category, because the reserved category is retrogressed. Unreserved category is retrogressed. So the Visa Bulletin for August just came out a few minutes ago. I did predict for it to be clear for the month of August. My own prediction is that we will be okay for the next few months, quite frankly. It did create a little bit of anxiety when it came out as late as it did. But I think we should be okay for the month of September as well. That said, I don't want viewers who are considering this to wait till last minute, because what most clients are surprised about, Edwin, is the fact that how much work is involved. So I just don't want anyone to be under the wrong impression that as soon as you decide, it can be filed the next week. This is a process. It's a collaborative process. And at my law firm, I do provide my direct WhatsApp information to my EB-5 clients from India, because I want to make sure you have access to me and our resources, and that we put our heads together and to address everything head on. So for those of you who are pretty serious about this, I do advise you to hire an attorney ASAP, because September 30th is right around the corner. Not only that, I do predict for the Visa Bulletin to be clear for the month of September, but, I could be wrong, because we do not have live data. I personally think we're going to be okay for the next few months still, but you never know.
Makes sense. Makes sense. Absolutely makes sense. So we've got some clarity between the reserved and the set aside. And in our conversations, we come across a lot of investors. So today at USIF, we have a HUA project, we have a rural project. So we wanted to understand from you, Marjan, does one between a rural and an HUA offer a real advantage over the other?
Yeah, well, with the rural project, rural reserved visas, which are at the 20%, those are really the only ones where the Congress has mandated for them to be processed with priority. And that's
Mhm.
something we are seeing in practice. They are being processed. Like if you asked me this last year, we were getting approvals for rural regional centers in about 3 to 4 months. This year, and again, this is just strictly anecdotal. We're receiving approvals from 7 months ago for rural regional centers. Now, I do believe that this is going to get pushed up further because of the bottleneck and the grandfathering effect. We're probably going to be seeing approvals in 10 to 12 months, as opposed to like 6 to 7 months for rural regional centers. Now, HUA has its own advantages too. Some people may feel like it does allow you like a stronger financial sense if you feel better about an HUA, and if you're living inside the United States, it could almost not matter, right? Because the I-485 itself does take a couple of years, and if the HUA takes around the same amount of time, then it should not matter much, right? However, and this is the big however, is that like, I personally have some clients who have selected HUAs and they've been waiting around for quite some time. And some of them date back to 1.5 to 2 years ago. And so it really comes down to your risk for appetite for risk rather. And as far as the quite frankly, I would opt for rural at this point, especially because of the time that it's taking for some HUA projects to process. That said, if everything else is the same, and if you are here on secure H-1Bs, you are don't have children who are about to age out, etc., it may make sense to go to an HUA project. So I think it's on a case-by-case basis. And that said, I do believe that the HUA may retrogress a little bit later because most people are opting for a rural project.
Got it. Got it. In fact, this is something that brings in a lot of value because a lot of people do not see that, that is one category which will get retrogressed because the kind of demand that it's bringing in, right? I
Correct.
just wanted to talk a little about the adjudication trends that you're observing right now, Marjan. So, what's the ongoing adjudication issues that investors should be aware of? The things causing delays, RFEs, or denials that might not be expected.
Yeah, so I have to be frank with you, Edwin, and we have discussed this previously too. I do tend to over document, and I drive some of my clients absolutely crazy. And I think there's a method to that madness. We don't want to open the door to an RFE and an unnecessary notice of intent to deny. So for all of you out there, I do recommend for you not to agree to a skeletal filing, because you want to make sure that everything is documented properly. That results into a lower incidence of RFEs or noise. The problems that we're seeing these days has always been there. Really, it's with the source of funds. Source of funds is really the main thing that USCIS generally picks on. And it's for cases that may not have sufficient documentation of cases where the third party money has entered into your account at any given point in time. That could become an issue. So I've made it a point to always ask that question. And when you ask this, when I generally ask someone, do you have third party money other than your W-2? Is there any gift or anything? And if the answer is no, I still keep on probing, because some people are under the assumption that if, for instance, you've lent a friend like $10,000, and then they return that money to you, that's still considered your money. No, it's not your money anymore, because it's coming from somebody else's pocket. And then you may put yourself in a situation where you have to explain that third party person's money, and then you may have to ask for their tax returns, for their employment information. And more people than not, they're just not comfortable releasing their information, right? So this is something that should be addressed very early on in your conversations with your lawyers. I think when we start looking at your bank statements, we do see some trends. If we see a trend of money coming into your account that cannot be explained, I may suggest utilizing another source of funding. So the source of funds has always been an issue. Is there a trend? they're just becoming pickier on
Yeah,
details. And one of the main reasons, Edwin, is because I do think they're using AI. I don't think they've opened up or confessed it in any public capacity, but I think that's why we're seeing some strange RFEs coming in where they're like extremely particular about things, things that maybe a
absolutely.
human will not pick up on. So yeah, so that's a problem. The birth certificates have always been an issue with Indians. There are some more RFEs that are addressing that issue. With that, what I've started to ask my clients to do is to go to the U.S. Embassy in New York or anywhere near you and to obtain a birth certificate confirmation from the U.S. Embassy in New York. They're pretty good at issuing that. They take roughly 10 days. So there are things you can do to prevent a potential RFE.
Got it. In fact, Marjan, thanks for that. These were very good insights, especially the one with regards to the AI, because we also have been coming across a lot of investors who come back with us, who are working with attorneys on the RFEs and all that. So this is very critical. With that, I would want to move into the last topic of discussion, the $800,000 question, which is the 30th September deadline, right? So Marjan, how have you've been through the EB-5 deadlines before as well. You've got
Oh,
excellent
absolutely.
experience. What actually happens in the market and at USCIS in the final weeks as the deadline approaches, as the sunset date approaches?
Yeah. So for one thing, the mailroom, they start making more mistakes. The mailroom at USCIS is notorious for making mistakes. And then when they get inundated with additional filings, they bring in more people who are not as experienced, if you will. And we do see more bounce backs, if you will, right? So we've had cases that bounce back for no good reason. And then I've had in one of the previous deadlines where the money was increasing from $500,000 to $900,000, and this happened during the Trump's last administration, and then it was later on it was pushed down to 500 again. But I remember distinctly there was this crazy deadline where it was the amount was changing from 500 to 900K, and then there was this rush, very much like what it is today. And we had one case that kept bouncing back, and we actually had to utilize a local congressman to get it through their head that they're making a mistake. So the third time was a charm, using a congressman getting involved here. So they do make mistakes. So that's why it's even more important to try to get your files out sooner than later, because as you get closer to that September 30th, like crazier things will happen. So yeah, so the mailroom has always been an issue. I've been doing EB-5 since 2010, guys. So I've seen a lot of crazy things happen, and we are ready to file for individuals who are our existing clients before any sort of retrogression. So if, God forbid, we see September being retrogressed, we are committed to filing for our existing clients, and that's what we intend to do. But you are going to see a lot more mistakes, with the mailroom. So you got to be mindful of that.
Just one last question before we could take one or two questions from the audience here, Marjan. There's also the January 1st, 2027 date, which a lot of us are hearing, right? So what is this automatic increase in the investment amount, and why does the filing date determine which amount? So if you could just add a little
Yeah,
on that.
absolutely. So within the Reform Integrity Act, as we know, they extended the amount of $800,000 for 5 years. Now, the September 30th, the grandfathering concept is a brand new concept that even though we've had crazy stuff happening, this is the first time we have a quote unquote grandfathering thing, which has caused a lot of panic and chaos within the industry. But for individuals who file before that date, you're guaranteed that your case will be processed at the 800K. Everything, if everything else looks good, you should get approval, right? But for individuals who file, say, on October 1st or later on, if the program is not renewed, then it's possible that you may not be processed under the same guidelines. As far as the amount that is going to go up to, it will likely go up to something like $937,000. They sometimes round up or round down amount, but what we know for sure is that the amount will increase once the program is renewed.
Got it. And now that we are staring at the deadline in just another 2 months' time, what do you think that an investor should do in order to avoid missing the deadline? And if you could just add some more insights on that, and we can open it up.
Absolutely. Absolutely. So there are some limiting factors, is what I call them. I used to be a science major, so in chemistry, there's a limiting factor concept, right? The limiting factor for EB-5 is your medical exam. A lot of people don't realize there's a medical exam involved, and that without that, your I-485 applications will not be accepted. So whatever you're doing, I think it's important to find out who are the civil surgeons near you. Civil surgeons are medical doctors that are professionally trained by USCIS to perform medical exams for green card applicants. And so I would just, even if you're like 80% sure you're going to do this, do your medical exam because they do not expire. So just type in Google USCIS civil surgeons, then you enter your zip code, and you'll go to take care of that. Another very important time-consuming thing is gathering your financial documents. So most people don't really realize how document-intensive EB-5 is until they actually start looking at it. So I would ask for your tax transcripts from the irs.gov. They generally give you the last 4 years, but then you have to fill out another form to get the seven for the full 7 years. So don't rely just on your tax returns. At a minimum, get your tax returns in order, but try to order your tax transcripts as well. Those are preferred with USCIS because they actually show that you've paid your taxes, and it's more valuable for USCIS. So get your financials in order, 7 years of tax return, make sure you have your W-2s, get your employment letters from your employer stating when you were hired, how long you've been with them, what is your annual salary, what's your position, etc. So if you're planning to do any sort of a self-directed IRA, again, if you have no other options but to use a self-directed IRA, start talking to your regional center because each regional center has their own connections with the custodians. Have that conversation early on, especially because now that it's becoming less popular, your choices may be limited. I know some regional centers which have strictly stopped using SDIRA, and I also know some of my own friends, good lawyers, who have just completely stopped taking SDIRAs, which is on the conservative side. I still leave it to the clients. I believe that you should have a choice, but just know the risks as well. Right.
Sure.
So these are conversations you should be having with your lawyer, with your regional center. And don't assume, try not to finalize your project and then call a lawyer, because those two things can be done in parallel to each other.
Absolutely. Absolutely. And that's exactly what we suggest to our prospective investors as well, Marjan, that finalizing a project is something that takes hardly a 10 days time, but your SOF can take much
Take
more.
longer.
Yeah.
Yeah.
So with
So
that, yeah.
No, I'm sorry. I was just going to say we still are trying to stick to a 4-week timeline for our clients. That number may get pushed up as we get closer to September 30th, but we are trying to commit to a 4-week turnaround time, provided that you're ready.
Wow, that's highly helpful, because we've come across situations where lawyers say at least 2 months. So a month is amazing.
Yeah, we have scaled up, Edwin, because we
That's
saw this
amazing.
coming, and we have scaled up, so we're still able to offer that.
That's amazing. In fact, I would want to take a couple of questions. I know we've ran out of time, but just we can accommodate one or two. So we have a question stating, can I apply the loan from Fidelity 401k account, contributing through my employer's pre-tax amount, and borrow the funds for EB-5 investment? That comes from one of our attendees.
So if we're talking about some type of a margin loan, then yes, I guess I would have to see exactly what they're talking about. But you can definitely utilize your stocks as your holdings as some type of equity. So very much like a home equity line of credit, any form of securities that you're holding can potentially be used to be borrowed upon, as long as you can prove that you're the true owner of that equity, albeit stocks or a home, then borrowing against that should be fine.
Great. There's one last question that I would take from the audience, which is my son, H4 or F1, which one is good to be on in regards to EB-5 GC process or in general? Investing on my
Okay.
son's name. He's 18 now. Will the parents also get the GC?
Okay, so that's a very good question because the son being 18, as we all know, he can no longer be on H4 after he is 21. So depending on how many years he plans to study, for example, if he wants to be a medical doctor, it may be better to just keep him on an F1 so you don't have to worry about changing his status down the line. So the closer you get to 21, it may be better to just have them switch over to an F1.
Great. One more question we can take here, Marjan, is if we file for EB-5 for a rural project, let's say in September 2026, within how many years we will get conditional GC?
That's a $1 billion question, guys, right? So it really depends on retrogression. It depends on how badly it's going to hit, right? So the retrogression matters at two junctures. It matters when you're filing your EB-5, which is now, because it allows you to file for your adjustment of status at the same time that you're doing your EB-5. It also matters when they go to adjudicate your I-485 petition. So, and that's where your priority date becomes key, because the earlier your priority date, the more likely you will get your I-485s adjudicated. So right now, I do estimate a timeline of 2 years, 1.5 to 2 years, not considering retrogression for an I-485 to be adjudicated, given the bottleneck that we're experiencing. So let's say in 2 years, they go to look at your application for I-485 adjudication, and you happen to be from India. And if India is retrogressed, then your priority date is going to be key, right? Is it going to be 7 or 8 years like some people are predicting? I personally don't think it'll be that bad. Whatever it is, Edwin, I honestly don't think it's going to be anywhere as bad as things are with EB2 category. So this is something that you have to take the lesser of two evils, if you will, right? Are we going to hit retrogression? Absolutely. Is it going to be anywhere as bad as it is with EB2? I do not think it will be. So you just, take that with a grain of salt. I think for individuals who can afford it, they should not lose this opportunity, especially because it does allow you to have advanced parole. It does allow you to get your EAD card, so that, I know a lot of people are unsure about their jobs and their positions. So this does open up the option to actually have another job. Some people decide to go and, do their own business. The other critical thing that it will help you with is your travels, because I know things are terrible at the U.S. Embassy in India with visa stamping, etc. So I have a lot of people who do it strictly just for travel purposes, and if they can get their green card faster, which I think they will, then that's always great as well.
Great. And there's one more question, very India specific. So if anyone filed EB-5 from India, entering in the US in July or August, can they do an adjustment of status, and when?
So we can't advise you to do that with the intention to stay, right? So that's exactly what the government is trying to avoid, and that's always been the law. It's nothing new. It's just that they're more aware of it, and they're probably going to enforce it even further. We used to have this 90-day rule as a matter of policy, where, like, if you were here for 90 days and you decided to do something else, so if you entered with the true intention to just visit your children, say they're here on F1 visa, and then you have no plans or intent to stay, but then all of a sudden, let's say a war breaks out, or like something major in your life changes that makes you want to stay here as opposed to going back to your country, then after 90 days, it historically has been okay for you to stay. But under no circumstances should you come here with the intention to stay, because that would be considered fraudulent. So I don't recommend that.
Got it. And there is a very specific attorney-related question, right? Because I know that investors get buried under a lot of papers. So we have a question where the individual says that I have 25 years of work experience and worked with 12 employers. Do I need to provide the employment offer and relieving letters from all the employers?
Absolutely not. What I usually do is I would get a one-page resume from you. This is not an NIW. It's not a EB-1 application, right? So they just you have to get a sense of who you are. So I would just get one-page resume from you with the most recent employer letter. You should not have to get employment information from anybody else.
Got it. Wonderful. In fact, we can take one more question, I guess. Just give me a minute. Okay. If inside in the US, is it a good idea to do consular processing and later do AOS instead of concurrent filing?
So you can always, if you're not interested in doing concurrent filing now, you can always choose consular processing just to be on maybe a very conservative route. And if you don't have children who are aging out, you may choose to do consular processing right off the bat. If you change your mind later on, provided the visa bulletin is current, you should theoretically be able to file for your adjustment of status, right? However, I don't necessarily recommend it for an Indian national because of the visa bulletin and the instability. So if you do think your ultimate goal is to adjust status, you should just choose or select adjustment of status. If you were from England or any other country that doesn't have a retrogression problem, then you could very well choose to just consular process and things should go fine either way. But then if later down the line you decide to adjust status, you always should be able to file. In fact, when the law changed, we had a lot of pre-RIA guys for whom we filed adjustment of status. So as long as you have a valid EB-5 petition, you should have the ability to file for your adjustment of status down the line, provided
Right.
the visa bulletin is current.
Perfect. In fact, with that, we'll call it a wrap. In fact, thanks, Marjan. Very
My
insightful.
pleasure.
Very,
My
very
pleasure.
insightful. And thank you to everyone who has attended the webinar. We'll actually be sharing the link as well. And the contact details for us along with Marjan is up on the screen. So anyone who needs to get in touch with us, please feel free to do so. With that, we will continue to associate more closely with Lawmaks and keep our association and doors open. Looking forward to a couple of more webinars like these in the future as well, Marjan. Thank you so much
Look
for your time.
forward to it. Thank you for having me, guys. Bye-bye.
Take care. Bye-bye. Bye.
Bye.